All right, let's get right into it. Today's explainer is a deep dive into a landmark constitutional showdown, one that literally tested the foundations of the justice system itself. We're looking at the massive South African Constitutional Court case, Van Rooyen versus the state. It's a fascinating story about power, structural integrity, and what it actually takes for a court to be truly independent.
Which brings us to a rather wild question. Can you overturn a criminal conviction just by proving the court itself isn't independent? I mean, it sounds like something straight out of a legal thriller, right? But that's exactly what happened here. Convicted criminals tried to get their trials completely tossed out on a systemic technicality, basically arguing the courts that sentenced them were structurally flawed and unconstitutional.
Okay, so we're going to break this judgment down into 6 quick parts. First, the challenge to the courts. Second, defining true judicial independence. Third, judges versus magistrates. Fourth, the Magistrates Commission debate. Fifth, evaluating the safeguards. And finally, the final verdict. Let's jump into Section 1, the challenge to the courts. To really grasp the gravity of this case, we've got to look at the claims that sent absolute shockwaves through the legal system. The accused here, Van Rooyen, Shabalala, and Themelaros, were facing some extremely serious charges, everything from theft to murder and fraud. But instead of just arguing the facts of their specific cases, they went big. They challenged the trials themselves. They claimed the lower regional courts lacked institutional independence, basically arguing the executive branch, specifically the Minister of Justice, had way too much control over the magistrates. And the craziest part, the High Court actually agreed with them. Yeah, the High Court sided with the accused, and they used some pretty explosive language to do it, declaring the magistracy has become the personal fiefdom of the Minister of Justice. Fiefdom. I mean, that sweeping statement implied the lower courts were fundamentally compromised by political interference. So, boom, absolute crisis. The Constitutional Court had to step in immediately to resolve this. Which brings us to Section 2, defining true judicial independence. So the Constitutional Court steps in, and they have to methodically define what true judicial independence actually means under the law. And they did this by splitting the concept right down the middle. First, you have individual independence. That's a single judge's completely free state of mind to decide a case, without fear or favor. But that wasn't what was under attack here. It was the second part, institutional independence. This is the court's structural relationship to the rest of the government, which absolutely has to rest on objective conditions and guarantees. And to figure out if that structural independence was actually there, the court used this really brilliant narrative device called the objective observer test. So put yourself in these shoes for a second. You aren't supposed to be hypersensitive, cynical, or looking for massive conspiracies. Instead, you're asked to evaluate the system as a well-informed, thoughtful, and objective observer who really understands the country's complex history and its constitutional values.
Moving on to Section 3, judges versus magistrates.
Now, our objective observer has to recognize that not all courts are built exactly the same under the Constitution. The High Court basically assumed that if magistrates didn't have the exact same protections as High Court judges, well, they weren't independent. But the Constitutional Court pushed back on that. They pointed out the real differences. Higher courts have inherent power and direct constitutional appointment rules. Lower courts, on the other hand, are historically courts of first instance. They actually used to perform administrative civil service duties, and their jurisdiction is strictly defined by legislation. The Constitution itself just treats them differently. Drawing on a famous Canadian case called Valente, the Constitutional Court noted, the essential conditions of judicial independence must bear some relationship to that variety. Basically, independence doesn't require a one-size-fits-all formula. Lower courts just don't deal with the exact same constitutional tensions as higher courts, and they are subject to appeals anyway, which is a massive built-in safeguard. All right, on to Section 4, the Magistrates Commission debate. This gets us to the absolute heart of the controversy. Who actually controls the people who appoint and discipline the magistrates? If you trace the history back to 1917, magistrates were literally just government civil servants. But watch how it evolves. In 1993, the Magistrates Act starts breaking them away from the public service. Then, the 1994 interim constitution explicitly protects their independence. And finally, in 1996, the new constitution kicks in, and changes are made to the Magistrates Commission to align with this whole new era. Now, the High Court looked at those 1996 changes and saw an executive takeover, a total power grab. But the Constitutional Court hit pause and highlighted the transformative context. You see, before 1994, the justice system was completely unrepresentative, mostly white men.
The post-1994 changes to the commission weren't a power grab. They were desperately needed to fix massive racial and gender disparities, bringing the courts closer to the actual diversity of the society. The High Court called it a fiefdom, right? But look at the actual makeup. Out of 27 members on the commission, you've got a high court judge as chairperson, 6 magistrates, 5 legal practitioners, a law teacher, members of parliament, including opposition parties, by the way, and executive nominees. Nearly half the board is from the legal profession and judiciary. This incredibly diverse mix completely dismantles the myth that a single government minister was somehow pulling all the strings. Let's look at Section 5, evaluating the safeguards. Okay, so the structure is diverse, but what about the day-to-day? Could the executive secretly pressure magistrates by messing with their paychecks? Well, let's follow the money. A magistrate's salary is determined by a really rigorous, multi-layered process. Step 1, the independent commission makes a recommendation. Step 2, the minister consults them and the finance minister. Step 3, Parliament reviews the salaries, and get this, they are the only ones who can actually reduce them. Finally, Step 4, it's all subject to ultimate constitutional control. The courts can strike down any decision that threatens judicial independence. So unilateral executive manipulation, basically impossible. And that exact same rigor applies to discipline. The code of conduct isn't just secretly written by a politician in some back room. It's drafted by that diverse commission we just talked about. Any regulations are subject to super strict parliamentary and constitutional oversight. Now, the Constitutional Court did make one critical little fix here. They ruled that if the government ever wants to recall a member of the commission, they absolutely must use objective criteria, not just their own personal opinion. So the crucial point here is captured perfectly in this vital principle cited by the court. What counts is not any abstract theory of separation of powers, but the actual separation of powers operationally defined by the Constitution. Total separation of powers, where the branches of government literally never interact, is just an abstract myth. It literally doesn't exist anywhere in the real world. The constitutional reality is a dynamic system of checks and balances. The executive and legislature having a role in appointing judges or setting up commissions isn't a flaw in the system, it's a core feature of a working democracy. Which brings us to Section 6, the final verdict. After analyzing the structure, the history, the safeguards, all of it, the Constitutional Court ruled definitively that magistrates' courts absolutely are institutionally independent. The High Court's sweeping invalidations were entirely overturned. The Magistrates Commission was upheld as a totally valid, independent check on executive power. The court only required a few minor, really precise wording changes to the laws, like removing that subjective power to recall commission members we mentioned earlier, rather than throwing out the entire justice system. And here is why this actually matters to you and me. The reality is that these mechanisms, like the Magistrates Commission, act as a vital, independent shield. They ensure that the lower courts, which, let's be real, are the courts where average citizens are way most likely to seek justice, remain fair, impartial, and totally free from political dictation. Which leaves us with this final, kind of provocative thought to chew on. How does your local court system balance accountability to the public with total independence from politicians? It's an incredibly delicate balancing act that literally keeps democracy alive. I really hope this explainer gave you a clear, structured understanding of just how much thought goes into protecting that balance. Thanks for learning with us, and keep asking those objective questions.